Good morning, Your
Good
Honor.
morning. How are you doing?
Good.
All right, where's Mr. Bach?
Oh, he's right here, Your Honor.
Hello. All right, so has discovery been completed?
Yes, Judge, we uploaded that discovery package to the defense asked for.
Okay.
My understanding is that the defense isn't receiving it.
Yes, Your Honor, we are.
So I need an acknowledgement of discovery today. State, were you able to tender an offer?
We had already previously tendered an offer, Judge.
All right, Norma, on this case, how old are you?
21.
21. Norma, can you set this for the week of September 16th for a plea deadline date?
Yes, and I can do the 17th.
All right, we'll come back on September 17th. That's going to be your plea deadline date. At that time, you'll need to let the court know whether you all have reached an agreement. If you have not, after that date, it's going to be a jury trial date. Do you understand?
Yes.
All right, thank you for addressing appropriately for court. Once you sign the reset form, you excuse and counsel. Once you do the acknowledgement of discovery, you all excuse. It's September 17th. You're welcome. Sure.
Second row.
Ms. Cleed has here.
All right, thank you. Renee Signs. Dean Pablo Delgado. All right. Are you ready to go on the record?
Yes.
All right.
Bach. Jody.
All right. I have Alfredo Flores, Elazar Alejandro, and Nathaniel Villalobos. Do y'all want to have this hearing on this state's motion for continuance at the same time or do it separately? All right, you're the only one who responded. So anyone else?
I concur.
Yes. All right, and state, are you okay with hearing these all at the same time?
We can take them up at the same time on the issue of,
The continuance?
yes, Your Honor.
Okay, all right, come forward, everybody.
Your Honor, if you want.
Yes.
Okay, yeah.
Deputy Laura, it's 3 clients, so it may get a little crowded.
It's fine.
Do you want us in the ABC order or does it?
She will let you know. I'm just calling it, you can do that if you want to,
Okay.
however you want to do it.
I just want to be sure.
Oh, no.
And just move up where the microphone is at.
All right, court is calling 2000. I need everyone to be quiet, please. Court is calling 2023 CR 11510A, State of Texas versus Alfredo Flores. 2023 CR 11510B, State of Texas versus Eleazar Alejandro. 2023 CR 11510C, State of Texas versus Nathaniel Villalobos for the state.
Jeff Mulliner and David Lunan for the state of Texas.
All right, in defense, if you could announce yourself and the corresponding client for the record, please.
Tom Nisbet on behalf of Alfred Flores.
Ben M. Cifuentes Jr. With co-counsel Mario Del Prado for Alejandro, Eleazar Alejandro, I'm sorry, Your Honor.
Okay,
Nico LaHood, Jason Goss, and Patrick Valentine for Nathaniel Villalobos, Judge.
all right, so the state has filed the first motion for continuance. Defense, have you had an opportunity to review that motion?
Yes, Your Honor.
All right, state.
Yes, Your Honor. We do affirmatively move to continue the matter for the reasons stated within our verified motion.
All that legal firepower in one room, and still a simple motion stalls. Sometimes it's not about the law, it's about timing, personalities, and a dash of courtroom chaos.
All right, do you want to expound on anything before the court makes its ruling?
I can highlight some things that are within the motion, Your Honor. The fact of the matter is, again, this is Jeff Moner for the state of Texas. I did not even know the names of the defendants that are charged individually in this case until approximately 30 days ago today, when I was asked to assume the role of director of the Civil Rights Division. Subsequently, of course, I have been getting up to speed on the cases, but that has been in stair steps. And when I became confident that the cases were in fact mine, it was about 10 days ago or less. And on that date, I reached out to the defense and we set up a Zoom conference. During the conference, there were attorneys representing each of the individuals that are charged in these separate indictments. And I was on the line with Chief Lunan and a lawyer for each of the defendants. And what I learned during that conference is that the counsel for Alfredo Flores, Ben Fuentes, and Mario Del Prado, in fact, told me that they have an expert that is necessary and material for their defense that is not available on the present trial date. I further learned, I'm sorry, that was David Christian and Tom Nisbet have an expert that is not available for the presently scheduled trial date. I learned from Ben Fuentes that he and Mario Del Prado, with respect to Alejandro or Eleazar Alejandro, have an expert that is not available for the present trial date. I learned from Mr. LaHood, Mr. Valentine, Mr. Norton, and Mr. Goss that they have an expert that is not presently available for the current trial date. And I expressed to them in this Zoom conference that Chief Lunan had just recently been asked if he would sit on the case and had not yet had an opportunity to review all the evidence. I had just come onto the case and had not yet had a chance to review all the evidence. We basically agreed that the defense feels that it would be a benefit to them that there are fresh eyes looking at the case in order to kind of just make a fresh assessment as to what we're looking at, what we should proceed on. And so I learned that they don't have an objection to the state's request for a continuance. And so from there, we basically all agreed that each for our own individual reasons had a basis for a continuance, that none of us objected to the basis that was advanced by the others, and that we would all file our motions and submit them for the discretion of the court to consider. So obviously it's your discretion what to do going forward, but on behalf of the state of Texas, we have not filed our motion for the purpose of delay, but rather in an effort to see that justice is done. And we do so urge that the motion be granted.
All right, so I don't have any motions for continuances from the defense, is that correct?
We filed ours.
All right, well, let's pull that so we can put that on the record as well.
Okay.
Does anybody have a motion for continuance?
We filed one, Judge.
All right, can you pull
I'll
that?
pull them up. The e-filing is not quite computing. so
Oh, that's okay.
e-file.
Does anybody have a copy of their continuance with
I
them?
have a copy of mine.
Oh, thank you. I knew you would. Anyone else have a copy of their continuance?
Judge, I can email it to your clerk if.
Oh, that would be awesome.
And I suppose I should give you time to read that unless you want me to.
No, just give me
Here's the insider truth. Courtrooms run on people, not gears. Promotions and transfers might shuffle the deck, but the trials still have to be played out.
What is your email address?
1 second, I'm looking for a multiple odds.
Okay, so don't email us.
No.
Okay.
You can send it to me.
Okay. What is it? Norma Dot
And Ferguson.
and Ferguson.
You found it on 8/20, right?
all right, and so we're also proceeding on a motion for continuance from the defense in each of the cases. Is that correct, defense attorneys?
Yes, Your Honor. And if you want me to,
Yes.
comment on some of the things that Mr. Molnar, that dovetail in
And I'm
my,
sorry if you'll state your name for the record.
Ben M. Cifuentes Jr.
All right, so you filed a motion for continuance on the behalf of Mr. Alejandro, is that correct?
Yes, Your Honor. And
You may proceed.
Axon Video, there were 109 videos provided. And they're voluminous. I would imagine they'd probably take several hundreds of hours, probably 500 hours to review. We have been diligently transcribing them. But to properly defend our clients, we need to synchronize the videos. We previously had asked the state if they could provide the evidence.com program and the Axon program so we could accomplish this task. The state advised that it was up to the PD to provide the program and they couldn't provide it. So upon learning that, we immediately hired Knott Laboratory out of Colorado to accomplish the synchronization.
All right, and what date was this requested?
The Axon videos, I believe we requested it in the previous setting. I cannot give you a precise date when we were told that it wasn't provided, but I could give you the date when we hired Knott Laboratories, and I believe that was 3 months ago. And they have been assembling these videos, and I think under rule of evidence, I believe it's 1006, we would be permitted to introduce these videos as cumulative summaries, and they're vital to our 9.33 defense because the prosecution guide omitted 4 different segments of time that would prove our 9.33 defense. And Sean Knott is the person who assembles these, and he has a trial conflict in another jurisdiction. In addition, we asked for the audit trail for Axon video, and that was not provided to us. And the reason the Axon audit trail is vital is that evidence.com is an evidence-based program that has software that can show when investigators accessed a particular video. And so if they ever accessed the points in time where we believe there's a defense, we believe we're going to be able to show that they did not even look at that. And so if they did not even look at exculpatory evidence in the videos, that would create reasonable doubt in our view. In addition, what we do know from what we were provided is that the videos were not uploaded until well after the warrants were issued. And some of the videos were uploaded in December or September, late September, well after the fact. And it appears from what we've been provided so far that the state, the PD has not even looked at these videos. In addition, we subpoenaed certain records from the DA as the custodian of records, and one of those was a murder case where our client responded to, and where a person was hit with a hammer several times, and there's an issue as to whether a hammer is a deadly weapon. It's a murder case. I will say that I did meet with Mr. Molnar on Thursday to address this subpoena that we issued that hasn't been complied with, and he is in the process of downloading. I believe he's already downloaded and will provide after this hearing a copy of those files by USB. So we're asserting that without our expert and without some of the evidence that we requested, the audit trail and the homicide file, that we would not be able to present adequately our defense of apparent danger and fear of serious bodily injury or death by a hammer. And that's why we're asking for the continuance. And we were diligent in trying to obtain Mr. Jason Evans.
All right. Anyone else want to have from the defense? Mr. Nesbitt?
Sure, Judge, Tom Nisbet on behalf of Alfred Flores. We filed our motion continuance, first motion under several provisions, 2906, 2902, and 2903. It's our understanding with the state that the unopposition is something of an agreed, but we also set forth the appropriate reasons under 2906 that our expert, which was duly noticed to both the state and the court and filed as such, Mark D. Sawa, is unavailable for the present trial dates. Despite counsel's diligence, he is a material witness. He is a nationally accepted expert in police practices, use of force, self-defense, and tactics, and goes to the very critical heart of the defense in this case. I would say to both the offense and the defense in this case, right? It is the critical issue in this case. His unavailability would deprive Mr. Flores of his right to due process and a fair trial. He is a retained expert. Considerable time and resources have gone into his preparation for the trial, and he is still receiving new evidence that we are obtaining and giving to him for his review. Judge, we agree with the aforementioned technical reasons that Mr. Cifuentes gave. Mr. Cifuentes and I spent a considerable time over the weekend looking at all the audit trail documents, and they are in fact missing any time signature, timestamp, identification, or any other evidence that someone looked at any of the body camera videos prior to September of 2023 in this case. So either that's not right, or that seems very, very problematic considering that it happened and they were all arrested in late June of 2023. So there has to be something missing there, or it is a major issue for the state and is extremely exculpatory, and either way needs to be vetted to the maximum. Anecdotally, we have heard in our investigation of this case of a type of chilling effect that has gone on in the San Antonio Police Department. What I mean by that is that officers who are presently serving in different ranks and capacities at the San Antonio Police Department have been discouraged from stating an opinion they may have that could be different from that of Chief McManus and the very administrative and political position that he speedily took in this case on the incident date. It is our opinion that a further investigation could show that there are good witnesses, exculpatory witnesses with exculpatory opinions to the defense, and we have been diligent in trying to examine those. There have been some new leads that have come up in the last couple of weeks. We have expressed all of these things and more to Mr. Muller and Mr. Lunan, and they have pledged the utmost due diligence and ethics in following up and being fair, trying to discover these exculpatory things. But I guess the best analogy I can give is it's kind of like, you know, the string on the sweater. You give it a tug and then it keeps coming. And that's sort of the situation that we're in right now. For all the aforementioned reasons, under Chapter 29, we would urge our first motion for continuance, and we are unopposed to any of our co-defendants or the state. And then I guess I will add, Judge, for the reason also listed in our motion, that it is the solemn desire of all three defendants and their attorneys to try this case together in joinder. So for that reason as well, we are not opposed to the motion for continuance.
And I apologize, Your Honor, I failed to state that I do agree with co-counsel that we do wish for joinder.
All right.
And Jeff Mulliner for the state, I should drop a footnote to come back and address this matter later after counsel from Mr. Villalobos have an opportunity to address the court with respect to their motion for continuance.
All right. Yes.
Judge Patrick Valentine from Nathaniel Villalobos. We agree with and join in the arguments of our colleagues just made. I won't reiterate the points that they put before the court. I will say particular to our motion, we are seeking a continuance in parts based on the unavailability of a material witness, that being Dr. Ron Martinelli. Dr. Martinelli is a nationally recognized expert in the field of police procedures and use of force. He has been retained by the defense to consult and provide testimony on the issues of the reasonableness of defendant Villalobos's use of force, the justifications of his use of force, and the integrity of the police investigation that was conducted. He is necessary and material to the defense. He is unavailable on the dates presently set for trial. I do have dates when he will be available for the court, should the court grant our motion for continuance, and we so ask the court to do.
All right, and you wanted to add something?
Yes, Your Honor. Insofar as it has been mentioned, the concept of a joint trial, I wanted to speak directly to the court and indicate that it is my understanding, based on some questions that I have asked, that the state of Texas has quite possibly seemingly joined in a joint trial insofar as the state has failed to object to proceeding with the joint trial. It's my understanding from a review of the law that ultimately it's going to be up to the court whether these cases are joined or severed.
Well, what I can tell you is both parties agreed. And when I say both parties, I mean the state and the defense attorneys informed the court that they wanted these cases tried together. Is my memory wrong?
They're correct.
That's our memory, Judge.
And there was no objection to the joinder. Now, as far as a motion of joinder being filed, the court has not received that. But we're all attorneys, we're all officers of the court. I don't think anyone would do anything that was unethical, but it was the court's understanding that the defense wanted these cases joined, that the state did not object to the defense wanting the cases to be joined. So is that going to be changed from the state's perspective?
Yes, Your Honor. My understanding is that the defense has, at a prior hearing, all agreed verbally in their desire to have a joint trial. And that my understanding, I wasn't there, and so I would always defer to a record or to a memory, but my understanding as someone that was not there is that the state literally did not object to what was understood to be kind of a consensus among the defense as to having a joint trial. And since—
Well, specifically what the state said was, yes, it will be a joint trial.
Okay.
Now, if people want to change and file motions, you can file your motions.
Yes, Your Honor. So,
But what I can tell parties is that based upon how I rule on the motion for continuance, that ship may have sailed because it was agreed by all parties that this would be a joint trial. And if my memory is incorrect, I know you all were not here, but if my memory is incorrect, please let me know.
It might have actually been two sequential hearings where it was addressed and assented to before the court. It's my memory, not just a single hearing.
All right.
Your Honor, if I may, all I can say is when I was asked to come into this case and when I first conferred and consulted with David Lunan, who had at that time just recently been asked, would he sit with my predecessor? When we were looking at the three separate cases that are here before the court, we each independently concluded very rapidly that there would be severe evidentiary problems to the cases for the state of Texas. Would there be a joinder, and specifically the confrontation clause? It's our view that if these cases were tried jointly, which I understand historically what the court has said about what has come before, but only speaking prospectively from our view, since the cases have not yet been tried, it is our view that if this were a joint trial, a great deal of the substance in this case that would be available, for example, just using the names, since if we wanted to put on the evidence that would be available against Alejandro Flores, much or most of the statements that Alejandro Flores had made either on body cam, his or others where his statements are heard, or in a statement that he had provided, would and likely could be objected to as denial of right to confrontation by Villalobos or Alejandro. Similarly, if we were trying to put on evidence as to Alejandro, there would be confrontation problems that could or likely would be advanced by Flores or Villalobos. And similarly, if we were trying to put on evidence against Villalobos, there's confrontation clause arguments that could be advanced and likely would be advanced by Alejandro and Flores. So with a joint trial, we see the evidence as being severely watered down insofar as by the time we got to
Oh, no. So let me just explain something to you. If you all have decided to have a joint trial and strategically, there are some issues with the confrontation clause. You know, people think, oh, this statement won't come in because we have a confrontation issue. Then that's going to be resolved with a jury instruction. Unless there is some other case law that somebody can bring me that will explain to me why, if 3 co-defendants decide they're going to try their case together, and maybe hypothetically a co-defendant is saying, I'm not going to testify, or another co-defendant is not going to testify, and then therefore statements don't come in for the other co-defendants. Excuse me, off the record. All right, thank you. No toddlers in the courtroom. All right, we're back on the record. So the court will take that up through objections at that time if that were to occur.
Yes, Your Honor. And also, I have heard, same as the court, that the defense is proceeding with what at least generally can be described as a joint defense agreement, but I have not seen a document to reflect the same. I certainly haven't seen signatures. And again, just hypothetically, for example, in this case, I think it's beyond dispute that Alfredo Flores held the rank of sergeant on the date of the alleged incident that's the subject of these 3 separate indictments, and the other 2 defendants in front of you, Villalobos and Alejandro, they had a rank of patrolman. And so there are, of course, distinctions in their role there at the scene. And from our perspective, we can't see how it would be possible for us to attempt to provide the evidence that's available against Flores, given his supervisory rank.
All right, so just a second, because we've strayed off the path of the motion for continuance, but this is what I will say. The state and defense agreed that all of the cases will be tried together. Now, if someone is now saying, we don't want to do that, you need to file a motion.
Yes, sir. Yes,
Court will hear the motion. So we're not dealing with that now. The only thing we're dealing with right now is the motions for continuance.
Understood. Thank you, Your Honor.
Sure. All right, so this is what I can say. In each cause number, the first setting in this court was January 29, 2024. It was for discovery. Then we came back on February 26, 2024 for discovery. Then we came back on April 29th for discovery. Then we came back on May 28th for discovery. Then on May 30th, we came back and I was told that all the discovery was received. All of the defense attorneys signed off on the acknowledgement of discovery. Then there was a plea deadline date set for June 27, 2024. And on June 27, 2024, jury trial was scheduled for September 24th, 2024. State, with regards to your playing catch up, the jury trial is September 24th. That's more than 10 days because today is August 26th. And each of the cause numbers for state and the defense, the motion for continuance is denied. And because of, I think Mr. Nesbitt said, we need more room for jury selection. So jury selection is going to be on Friday, September 20th in the central jury room. Is there anything else? All right. And then for experts, have you all subpoenaed them? That would be a no, right? No experts have been subpoenaed.
We've retained them.
All right. All right. Thank you.
Your Honor, May I have my copy back?
Oh, yes. Oh, I'm so sorry. Let me find your copy. And you are with, who's your client?
Alejandro.
Alejandro. Just one moment. All right, Jennifer, can you do me a favor? Can you make a copy of this?
Yes.
And I sign this one and I will get a copy of it.
Okay.
If you can make him a copy and give me the original.
Yes.
All right, thank
Go
you.
back and do that real quick.
Are we excused, Judge?
Yes.
Thank you.
All right, Ray Anthony Espinoza.